Hey guys, Tammy here, and today we're going to talk about what does your child custody judge want from you. Now, getting into your judge's mindset and understanding their perspective can make a huge difference in the success level of your case, in your outcomes. And so they don't come at it the same way we do. And so we tend to approach our case, especially if we're self-represented, the way we think about it, but you have to start shifting your mindset to understand what your judge is looking for. Before we dive into this video, let me just remind you, if you like this content, please hit like and also subscribe to my channel. And if you stick till the very end, I'm going to share with you how you can book a free call with me. So the first thing that the judges really want to see is they want to see cooperation. They want to see you stop having conflict with the other parent. And honestly, you know, we talk about how the person that wins is the person that can actually do this, because the cases that come in front of the judge are the cases that have high conflict, right? People that are able to solve their case without the court help and all that kind of stuff. Obviously, people that are having lower conflict or at least are able to work through it. So you have the top 20% of amount of conflict are the cases that are in front of the judge. And so this is what they're seeing all day, every day. Case after case after case where both parties are just going at each other. You can really become a breath of fresh air for your judge if you can stop having conflict. The second thing that they want to see from you is they want you to support the other person's parenting. Now, you may not know this, but actually in almost every state, there is something in their law in their state that talks about the importance of one parent supporting or both parents supporting the other person's parenting. Something very few people are able to do given the amount of anger, resentment, you know, all those negative feelings towards our ex that we have when we're going through this. It's really, really hard to be supportive for a lot of people. But this is really critical because ironically, it can often result in more parenting time for you if you can be the more supportive one, because the court takes the perspective of, well, if I give parent A, who's supportive, more parenting time, they're going to ensure that parent B stays involved. Whereas if I give parent B more parenting time and they're not supportive, then that parent is going to do all they can to exclude parent A. The idea of supporting the other person's parenting really becomes about the child having access to both parents, which is something the court views as imperative for the child, of course, absent any true safety concerns in the judge's view. So this kind of comes back to loving your child more than you hate your ex. And this is a phrase that I use commonly when I'm teaching people. You know, our love for our children and what's good for them has to come before our negative feelings towards our ex. And it's so easy to get in that mindset. You know, I was talking to somebody earlier today who said, look, you know, the other parent is accusing me of all these different things. And in actuality, the other parent is the one that is doing these things. And how do I get the court to see this? And how do I get the court to do something about it? The irony of that problem is that the court cannot control the other parent's behavior. Depending on the extremity of it, you know, will you get orders that control certain aspects of it? Sometimes, again, if the behaviors rise to the level of, you know, putting the child's safety in danger. But for most of us, it's not that level. It's really just annoying things, inconvenient things they do to make your life miserable, to make it harder for you, changing pickup times and locations and, you know, not cooperating, you know, on the exchange if the child doesn't go to school, or demanding that the exchange be at this time because the child didn't go to school instead of that time. Whatever, all the little different tricks that they pull to try to make life difficult. And the thing about that is that the court can't control those little kind of day-to-day behaviors. And when you're dealing with somebody who has a high conflict personality or the narcissistic traits, like I talk about a lot, them knowing that they upset you with those little changes actually cause you to get more of that behavior from them. So kind of taking the approach of, I'm never going to let them see me sweat. I'm going to love my child more than I hate that parent. I'm not going to let little things get to me. And I am never going to let that other parent see me sweat. And if you can take that approach with it, what will happen is you will start to get less and less of that behavior. And, when you get less and less of that behavior, you're going to be in front of the court less. You're going to make your judge happy. The court's going to see that you're trying to be cooperative, that you're not causing conflict over unnecessary things. And it's going to build your credibility when you are in front of your judge. The next thing that I would say that the courts really want from you is for you to be concise. This is such a struggle. And I honestly think that this goes back to not understanding the court's perspective. It goes back to educating yourself. You can't walk blindly through this process. You can't just rely on what seems reasonable or logical to you as a layperson, because again, how we're viewing this as a parent or a layperson is not the same perspective that the court has. And so if you're just relying on that, on your parental view of things, you're not going to be able to do this well. And you're going to be presenting all of this information and all of these, situations and communication with the other parent, all of this stuff that really isn't part of the court's biggest concern in your case. You're sort of throwing more volume at them, but not necessarily anything that's effective. Being concise is about learning what's important to the judge and what isn't. And this is critical if you're self-represented, but let me tell you that even if you have an attorney, this becomes really important because you don't want to be throwing everything that you have at your attorney and paying their hourly rate for them to sort through mountains of information. Thomas used to describe this as the client coming in and just kind of dumping a box full of papers on his desk and being like, okay, you fix this for me. That's the most expensive way to go about this process. Nobody knows your case better than you. Nobody's going to be able to narrow down the points for the judge and make it more concise than you. But the key is you have to understand what things are important and what things are not. And that's really the difference of the perspective that the judge and your attorney have. Is the attorney kind of knows what things the court's going to care about and what things they're going to find pertinent. I would encourage you, if you have an attorney, listen to them. Take their advice. If they tell you something's not important, accept that it's not important and move on. A lot of times attorneys, in an effort to please the client, especially inexperienced attorneys, I think, will go, okay, you want me to make 10 different arguments on your case? Sure, I'll do that. And then a lot of times you get in the courtroom and that attorney or that self-represented person either gets cut off because the judge is like, okay, this is like too much. You're not being concise enough and giving me a big picture. Or so they either feel like the volume's too much or the current thing they're talking about is irrelevant. So I'm just going to cut it off because what you're saying doesn't matter anyway. But maybe you had 3 more points after that were relevant, but you lost the judge because you went into irrelevant things. And so again, whether you have an attorney or whether you're self-represented, it's real important for you to educate yourself around what points of your case are relevant. And, every judge has a little bit different perspective based on their own experiences, cases that they've seen come in front of them, and all that kind of thing. And so you're not going to be able to read your judge's mind and know exactly what they're going to find important, which is why I always say, go watch your judge. go watch your judge. If you don't do anything else, represented, not represented, anything, go watch your judge on a day that you don't have court, that you don't have those emotions running. That will help you narrow in on what the judge really weighs heavily as cases come in front of them. You'll see things that are similar to yours. You'll see things that are very different from yours, but it will give you a lot of perspective, which will enable you to be more concise in your presentation to your judge. Make sense? I hope so. If you find this content helpful and you would like to book a free call with me, you can go to divorceuniversityonline.com/VIP-coaching. There's a link on that page you can use to book a free strategy session with me. Look, you guys, education is the key. Like I said, self-represented, attorney, it doesn't matter. Educating yourself is the key to success in your child custody case, and I'd love to support you in that. I'll see you guys next time.
Fueled by them to see the horizon, turn us to thousands.